Ano na, naka-broadcast ka na?
Yeah, I guess. No. I'm not sure if we're on.
Yes.
Okay. Hello, magandang hapon po sa inyong lahat. Maayong hapon sa inyong tanan. Good afternoon to everybody. This is the first lecture series of the Philippine Association of Law Schools, intended for our law students during our extended enhanced community quarantine. I hope you're all doing well right now. Maraming salamat for logging in. I hope your internet connectivity is okay as well. I would like to apologize now pa lang if there are some technical glitches. This is the first time that I'm actually doing a webinar, not using Zoom. Dean Mari, the president, and Dean Shuade last night had been trying to help me out, put up the Zoom and synchronize it with the live broadcast, pero mukhang mahina talaga ako. I'm not really a techie person, no? So we're trying to do this just Facebook Live. I was hoping to share some slides with you. I already forwarded some of them. Unfortunately, we had some feedback that some of the slides had low resolution. So the pals will eventually give you a copy later on after my lecture. Now, I was told to entertain questions later after the lecture, no? But just keep uh, the comments coming in, and when I see it, I'll try to answer as much as I could during the lecture itself while the issue is hot, no? So let us start. I think the pals had already uploaded some of my slides, no? So let's just go through the subject matter of the lecture. It's going to be a very simple lecture on an overview of labor law, because this is intended to supplement both the labor standards and labor relations as well as welfare legislation. And then we go into basic principles. So the flow would be actually just an overview of labor law, the interest of management as against the interest of the employees, and what we call the balancing of interest principle, where the government tries to balance the unequal status of both parties at the start of the relationship. Now, and then we go into general principles of law. Then I'll try to incorporate also the general flow in labor relations, because this will be a segue to the second labor lecture, which I think is scheduled on April 28 or 29, no? Just take a look na lang at your at the PALS page. I'm not sure when. And then after which we try to discuss employer-employee relationship, and then I will contrast it with independent contracting arrangements and the issue of NDOC, no, which is a very very uh, controversial issue. For the last 2 years, ever since the President Duterte said that he would like to end NDOC, no, and then we will also go into management prerogatives juxtaposed with the issue of employment classification. I hope to end there within the 2 hours, no. So let's start off. So what is basically labor? Labor is both a noun and a verb. it's usually, the synonyms are usually like work, employment, industry. You have the sweat of one's brow. You have a job, a chore, no? And in the context of labor law, it really means simplistically that labor is the service or the work rendered by a person to another who pays for the services. This is what we call the compensation aspect. Okay, so when you work for a person and that person pays you some kind of compensation or remuneration for the work that you did, then that is considered an employer-employee relationship. Okay, for as long as there is control. We will talk about that more in detail later. Now, labor, as we had already intimated earlier, is the exertion by human beings of physical or mental effort. It's not usually just physical, it could be just mental or even both. And it is used towards the production of certain goods and services in exchange for remuneration. No? Now, as a noun, labor could also refer to your work personnel. Okay, now, in class kasi, in order for me to be able to relate better, I would much rather that we consider ourselves one corporation now. I'm your boss. That's why most of my students call me Boss Chief. Okay? So I'm your employer, and all of you out there who are listening to me would be considered my employees. No? Now, in the context of our class, during the first day of classes, I already give roles, interactive roles throughout the whole semester. They're assigned roles. Some are managers, some are supervisors, some are rank and file. But in any event, for these purposes, just imagine yourself being an employee of, let's say, a school. No? Let's call the school COVID school para madali tandaan. So we're all in this COVID school. I own COVID school and you are all my employees. Now, so in that context, one question that was asked, why go into labor? Now, for the students, somebody asked me, Ma'am, why did you choose labor law? No? Sa totoo lang, I did not choose it. My father did. you know, I never wanted to be a labor lawyer in the first place, except that that was my father's specialization. And when he decided that I was going to work for him, then he said, okay, this is my field, you have to study it. But, eventually, notwithstanding the fact that I had certain misgivings in going into labor law, eventually I found it rather exciting, no? Hindi naman dahil porke puro lalaki yung kasama mo sa mga union, mga nakakasalamuha ko. Hindi naman ganon, no? But then again, I discovered eventually that labor law, as compared to even most other laws, criminal law, procedure, corporate law, I think for me, no, labor law is actually the most fluid of all branches of labor laws. That's why I loved it. Because you will find out, even when you read your Supreme Court cases, most of the Supreme Court cases would harp on the principles of social justice and equity throughout all of these particular cases that are brought up to it. Okay, so the principles of social justice and equity actually permeate throughout most of the labor cases that are assigned to you. Okay, so now, with that background, we now go into the basic principles of labor law. I have to tell you first what is balancing of interest and what are the interests of the employer as against the employee. No? So when we talk about labor, we talk about actually a human element. We don't run machines in the school. The school is operated through the personnel. Okay? So the basic element in labor law is actually the human element. So labor law, particularly labor relations law, pertain to the human relations between the employer and the employee. No? Now, the labor law therefore pertains to the governance of the relationship between the two sides. You have the employer, which is me, on one side, and managers, no? On the other side, you have you, the employees, no? Now, these two interests, you have invariably contradicting interests. If you have to look at it from a Marxist viewpoint, these two sides will never meet. They will always say it is contradictory because management would always want profit. On the other hand, the employees are deprived of their profits, okay? Deprived of their share in the profits. So, the balancing of interest is found in your Supreme Court cases and an exhortation in the Constitution, which says that there should now be a paradigm shifting towards cooperation. This is in recognition of the fact that if both management and the employees were to engage in adversarial positions all the way, all together during work, then it would result into a losing proposition for both. Because taken to an extreme, if the employees go on strike, the employer, on the other hand, loses the profits for every day that the employees go on strike. So there has to be some kind of a good relationship between management and the employees. Hence, the exhortation of the Constitution and the Supreme Court in cooperation between the two interests. So, the Supreme Court in one case even said, it is high time that the employer and the employee cease to view each other as adversaries, and instead, they should recognize that there is a symbiotic relationship because they must rely on each other to ensure the success of the business. And when the business is successful, then both will gain. No? So that's the case of Toyota Motor Philippines. Now, another basic thing that we have to remember is the fact that employment is not merely a contractual relationship. It has assumed the nature of a property right. Why? Because the employees are engaged in gainful livelihood. In which case, if one has work, then indubitably he could now support his family. So, being with work or without work may practically spell the difference whether or not a family would have food on the table, a roof over their heads, and education for their children. So, because of this nature of employment, the nature of employment not merely as a contractual relationship but a property right, then the state has made sure that it has undertaken measures to protect the employees from unjustified dismissals and or non-payment of wages. So now, you now see the balancing of interest here when the state already steps in. So again, work is a necessity. It has an economic significance. It deserves legal protection. So therefore, you now have social justice and the protection to labor provisions in the Constitution. So that's why we have this particular phrase, no? Take not from the mouth of the labor the bread that it has earned. So now, what's the basic premise and the framework in labor law? I call it the tension of opposites and the balancing of interest. Okay, so I now tried to discuss earlier the two sides, no? The management side and the employees side. Now, let us just try to discuss what is my interest, what is my viewpoint as the employer, as your boss chief. Okay, I control the capital. I have capital. I put in the capital in my school, this COVID school. Now, what is that capital? Capital is in the form of money, in the form of the place where we will work if I own the property. Also, the manner, the equipment that I put up, that is capital. No? Now, as regards how I will make use of my capital, that the direction and the disposition of that capital is what is called my prerogative. In labor law, it is called management's prerogative. Now, what is management prerogative? When we talk about management prerogatives, I tell my students, and my students will know this, it is simply the right of management to determine how to operate its business. So, the law recognizes that because I put in the capital, I am entitled to some kind of profit. Hindi naman ito charitable institution, di ba? So I put in capital so that I can earn. Instead of putting money in the bank, then I am allowed to tweak the variables in the business so that I will earn profit more than that which the bank will give me if I had put the money in the bank. So now, in the aspect of labor, therefore, this is the management prerogative is the discretionary power to determine all aspects of how I will operate the business. So it actually is my decision to who to hire, no, all the way to who I will fire. So from hiring all the way to firing, and everything in between. That is the operation of business. That is part of my management prerogatives. Okay, simply put. Now, what are examples of management prerogatives? You have work assignments. You have, I assign you what to do. I assign you how to do it. Okay, I tell you when. I tell you where you will do it, how you will do it. Yeah, the manner and the means of the work. What are the tools to be used? What are the processes to be followed? And then lastly, and the most importantly, I have the right to discipline you, to supervise you and discipline you to find out if you're following my rules. Yeah? That is part and parcel of management prerogatives. Okay? Now, so in terms of management prerogatives, it is the right to conduct business, the right to prescribe rules and regulations, the right to select employees, and the right to transfer or discharge employees provided that due process is followed and then it is done in good faith. Claro? Okay, so now we finished with the interest of management. Now, what do the employees want? What are your interests? When you work for me, what do you want? Huh? Do you put in capital? Do you put in capital so that you can be hired? Meaning to say, pumupunta ka ba dito sa COVID? Ma'am, i-hire niyo po ako, bibigyan kita ng pera para i-hire niyo ako. Ganun ba ang employment? No, that's not employment. Okay? If you have to put in money so that you can work for me, then that is not employment. Rather, that's a partnership or being a stockholder. But that is not labor or employer-employee relationship that is defined under the labor code. So, what do you have? Under the labor code, the employees only have their own work. They only have their labor. And so therefore, pumupunta ka ngayon dito sa school, no? Magpapahire ka sa akin, I will determine whether or not you will be qualified. Now, take note at the time of hiring, you already know that you are already economically dependent upon me once I hire you. Bakit? Because you are required to follow my rules, no? There is a difference here, no? In some countries kasi, in some countries you can actually negotiate, no? In some instances, even here in the Philippines, you can negotiate if you have equal bargaining leverage with the company. But that is actually the exception rather than the rule. What is the general situation? The situation is that coming to work because you need the work. So they can impose the terms and conditions of work. And if you like the terms and conditions of work and you qualify, then you get hired. You cannot bargain for the terms and conditions of work, no? As a general rule, no, you can't because you don't have real bargain leverage unless pinirate ka. Let's say, national artist ka for literature and I need you, you know? So you can bargain with me because I need you. But what if this was just a job for a simple library aide or a simple messenger? Okay? So, do you think you will have bargaining leverage with me? So that is the essence of the inherent inequality of both management and the employees at the time of hiring. You know, you cannot actually, you know, you because you're economically dependent, you need the job. you're already put at a disadvantage. Now, the law actually recognizes that inherent inequality between you and me at the time of hiring. You see? Nakita nyo na, di ba? At the time of hiring, inherent inequality na. So what does the law do? The law now tries to balance both interests of management as against the employee. That is where the principles of social justice, equity, and the police power come in. So you have the two opposing interests. There's a tension between the two interests of management and the employees, and then the state comes in the middle and tries to balance it. No? Especially so when the interest of management and the employees collide. Mag-aaway yan. No? So, the state steps in. How will the state step in? To balance the two. Well, as I said earlier, there's already a paradigm shifting towards mutual cooperation between the two parties. If industrial strife will continue between the employee that is hired and the employer, it will result in a losing proposition for both. So, in order to balance these two diametrically opposed interests of management and labor at the time of hiring, the state steps in to regulate the relationship. How does the state do it? The state implements legislation which is designed to protect the workers and also the employer. Okay, but more on the employees. So the state intervenes in that relationship between management and the employees by the promulgation of labor standards and labor relations laws. Okay? So now, what laws were actually promulgated to balance the conflicting interests? Remember, minimum wages. There were no minimum wages before. So the state came up with this particular uh, uh, law on minimum wages to ensure that each employee will be given sufficient wages as to sustain them. No? Then you have the 8-hour working day. Walang dati. No? Then you have laws on labor standards, yeah, 8-hour working law, overtime, etc., etc., service incentive leave pay, maternity leave, paternity leave, lahat yan. These were promulgated to protect the employees. Now, that's the labor standards aspect. On the other hand, you also have labor laws that relate to the political rights of the employees. What are these? These are the right to unionize, okay? The right to vote for a majority union, for an exclusive bargaining agent, so that they would be able to balance. So they would be able to bargain later on with the management for better terms and conditions of work. Please take note, the management is not under any obligation to give you more than which is provided for in the labor code. So the labor code is the minimum. Now, there is nothing in the labor code that says you have to give more than that. Wala. So how will you now get more than minimum? Then you will have to exercise the political rights, no? So unionization, collective bargaining, etc., etc., including the right to strike. So that will be next for the second series na of labor laws. Okay, and then most importantly, security of tenure. So which means that the employer cannot terminate you without just or authorized cause, except, and only after compliance with the due process requirement of law. So that now limits the management prerogatives of the employers. That is how the state now balances the contradicting and yet intertwined interest of management and the employees. Okay? Now, so just to wrap up this particular portion, before we go into employer-employee relationship. Now, in the balancing of interest, the law acknowledges that the dynamics must respond to the realities of life when has to resolve disputes between management and the employees. So you will now see that, not all rules are inflexible, because you will have to make use of the principles of social justice and equity at one time, no? One time or another within the context of a particular case. So, an inflexible rule cannot address the labor dispute with justice without balancing the interests of the employer and the interests of the employees in order to achieve an equitable solution. So that's how, we will have to look at the framework of labor law when we discuss now the management prerogatives, classification of employment, okay, etc., later on. Okay? So is that clear so far? Actually, hindi ko pala makikita yung inyong mga comments dito sa setup ko. Okay, kasi hindi ako marunong mag shift to shift. Okay, now, so, may mga particular questions on ECQ kasi. Pag-uusapan natin yan mamaya. Hintay lang. Tapusin ko muna to, no? Okay. So now, let us now parang recapitulate what we discussed, the framework of labor law. So you have management on one side and you have the laborers on the other side. Again, management puts in the money, it puts in the capital. Because it puts in the capital, the law recognizes the right of management to have some profits. So, in fact, the Supreme Court has said in one case, Chu versus NLRC, this is the room for profits. So management has a right to tweak the variables of the operations of the business so that it will gain some profit for itself. Okay? Now, how will it gain the profit? It now has the management prerogatives to determine how to operate the business. So I told you this refers to who to hire, how many will be hired, how much they will be paid, what are the kinds of employees that I will hire. Will they be all regular or will I put them into casual? Will I make them into a probationary first, or will I put them into project employment or seasonal employment or term employment? On the other hand, I might decide, and that's part of management prerogatives, and we will discuss this later. I might decide to contract out a particular job or service to a third party, which is called a contractor. Whether it's independent or labor-only contractor, we will discuss that more in detail later. So those are management prerogatives. Now, on the other hand, again, the laborer do not have anything except the work. However, paano na ngayon yung laborer? Do they not have any right to the profit? Well, the workers or the employees not say naman that they're entitled to all of the profits of the management. No, they don't usually say that. But they say, give us naman an equitable share in the profits. We have to be given an equitable share in the profits, because if we did not work in the manner that you dictated us to do so, then you would not have gotten the profits in the first place. That's why the law recognizes that they should also have an equitable share in the profits. No? Now, how does the law balance it? Then you have the workers' rights, which are now statutory rights, the minimum standards, the constitutional right to security of tenure, unionization, collective bargaining, and the right to strike. That is how the state balances. Because at the time of hiring, wala pa yung law na yan, wala pa yung labor code eh. No? At the time of hiring, as an applicant, you're still not employed. But once you're employed, then the labor code steps in. The labor code is deemed incorporated automatically into that relationship, even if there were no employment contract. Please take note. Disabuse yourselves of the thinking that an employment contract is necessary for an employer-employee relationship to exist. Read throughout the whole of the labor code. Walang nakalagay na kailangan in writing yung employment contract. Okay? So the fact that one has control is already sufficient to put up, to make an employer-employer relationship exist. Okay, so now let us now go into employer-employee relationship and the principles of no. Let's go muna to the principles of labor law before we go into employer-employee relationship. Ito yung mga overview muna, no? So when we calibrate the conflicting interests in labor, in life as well as in class. Halimbawa, you're taking an exam and you have an essay question. Okay? As much as possible, we assume that you have already read all of the cases that were assigned to you, and that will help you in answering your questions. But if, kamalas-malasan mo yung weren't able to read all, then at least try to remember these general rules because it will help you in calibrating and determining what is the correct answer for that particular scenario or situation. Okay, so let me, I think I put in one of your slides there yung constitutional basis and the statutory basis of labor law. No? I think it's Article 3 of your labor code. Now, Article 3 of your labor code actually is a declaration of policy. It is the basic framework of labor law. This is, I would like to think, the imprimatur given to the labor arbiters and the commissioners. No? That in case of a situation, no, and the two interests are so evenly balanced with each other, then the exhortation is this: that decision that will afford full protection to labor is the correct decision. That decision that will promote full employment and ensure equal work opportunities regardless of sex, regardless of race or creed, that is the correct decision. Now, that which will assure the rights of the employees, the political rights of self-organization, collective bargaining, so security of tenure, and to the just and humane conditions of work, that is the correct decision. So this is the exhortation. When things are in the balance, always, afford full protection to labor, full employment. You give assurance to the rights of the employees to their self-organization, collective bargaining, and such. Okay? So now, what are the general rules? First general rule, which you must remember, and this is in reference also to questions of jurisdiction later on. Number one, the existence of an employer-employee relationship is a condition sine qua non for the application of labor laws. Okay? This means that if this is not an employer-employee relationship, the labor code will not apply. Some other law will apply, but not the labor code. So, again, the existence of an employer-employee relationship is a condition sine qua non for the application of labor law. That's general rule number one. Now, try to memorize with me. General rule number two, you have now the principle of automatic incorporation. What does this mean? That once the employee is hired, no, and there is an employer-employee relationship, the labor code automatically steps into that relationship in order to balance the inherent inequality at the time of hiring. So, the minimum labor standards, the minimum benefits, as well as the political rights that are found in the labor code are considered inherent in that particular employer-employee relationship, even absent a written employment contract. Now, general rule number three. Once there is already an employer-employee relationship, then who bears the burden of proof? General principle number three says the burden of proof is always placed upon the employer to show the validity of the exercise of its management prerogatives, especially as regards termination of employment. Okay? So the burden of proof is always upon me, as your boss chief. Not you, but me. Now, general rule number 4. So, if the burden of proof is placed upon me as the employer, what kind of proof is required? Then the law says only substantial evidence is required. No? Now, general rule number 5. General rule number 5 says there is no retroactive effect of labor laws. Simply stated otherwise, then laws are supposed to be applied prospectively. What is the exception? It can be applied retroactively, but only if the law explicitly provides for such. Okay? And then last, general rule number 6. In case of doubt or ambiguity, then interpret in favor of labor. Okay? That's a very huge thing. In case of doubt or ambiguity, interpret in favor of labor. Which means, therefore, if the law explicitly states clearly the terms and conditions of the work, then there is no need for interpretation. If the terms are clear, okay, then there is no need for interpretation. It is only in case of doubt or ambiguity there is need for interpretation in favor of labor. Claro? Okay. Okay, so now let's go into employer-employee relationship, which is our general rule number 1. No? And general rule number 2, yung principle of incorporation. So, how will you know if the person is already an employee? Okay, how will you know? So, the Supreme Court has made use of 4 tests. And I want you to memorize it. I give this to my students. SWDC, Southwest Disaster Control. So, selection and hiring. Okay, this is the 4-fold test. S stands for selection and hiring. W stands for wages, payment of wages. Whoever pays the wages in all probability is your employer. Okay? D stands for dismissal. Disaster. Kaya disaster, dismissal eh. So, whoever has the right to terminate you in all probability is your employer. And lastly, and the most important test of all is actually what is called the control test. And the Supreme Court has more often than not used the control test to determine the existence of an employer-employee relationship. And the Supreme Court has, made use of the particular definition under the LVN case, no? Where the employer has reserved to himself the right to control not only the ends to be achieved, but also the manner and methods by which the ends will be achieved. In short, an employer-employee relationship is deemed to exist when I can control how you're supposed to do the work for me. Okay? Where I control the manner by which you will do the work for me, then that is an employment relationship. Claro? Okay. So now, try to memorize that particular definition, the old definition that is found under LVN case, which is 1 SCRA, no? The person for whom the services are performed reserves the right to control not only the ends to be achieved, but also the manner and means by which the end will be achieved. That is a classic definition of the control test. And I urge you, when you answer your exams, and so for the bar na, parang bar review na rin to, no? You try to insert that particular definition so you get extra points. No? Okay. Now, let's now go into some questions. May questions pa? Okay. Okay. I cannot see actually where your questions are. I will have to look at the other computer.
Walang questions.
Wala. Okay, so Wala
Ay,
pang
ito
question
lang,
so
yun
far.
lang yung regarding dun sa delayed release of the last
Okay.
pay.
So now, I said control is the most important test of all. So how do you determine control? In most instances, there are rules and regulations which the employees have to follow, especially as regards procedures, no? How to work inside COVID school. You have to come to work, you have to log in, you have to wear your uniform, you have to wear your ID, you cannot log out or log in for somebody else. Now, these are rules, no? Now, the question is, how do you know if that rule will give control? Because you have to distinguish between rules which serve as guidelines as against rules which fix methodology. No? Now, in rules which fix the methodology of how you will do the work. In short, I am dictating to you how, when, where, what, and why. Then that is a rule which fixes methodology that is now considered as control. I control you, in which case the law now says there is an employer-employee relationship that exists between you and me, okay? Where I am able to dictate the manner and the method by which you work for me. Then that is an employer-employee relationship. The labor code will step in. And I am now obliged to comply with all of the obligations that is found in the labor code, like labor standards and the minimum benefits. Now, on the other hand, what if the rules were merely guidelines? Meaning to say that these are not imposed upon you, but simply say that these are the parameters by which you can do the work. Then the law says that is not actually controlled because I will not dictate to you how you will do the work. I am just giving you the parameters on what are the results that I need when you do the work. Then that is not control. And therefore, the law says there is no employer-employee relationship between us. Okay? Now, let us discuss that further when we go into independent contracting versus employer-employee relationship. Let us try to, distinguish between the two later on. I just want to finish the general rules first. Okay? Now, general rule number 3. So we took up general rule number 1, employer-employee relationship. General rule number 2, principle of incorporation. Now, general rule number 3, burden of proof is placed always upon the employer to show the validity of the exercise of its management prerogatives. Now, please take note. Sa kabuuan, no, in the exercise of management prerogatives, burden of proof is placed upon me as your boss chief. However, you, on the other hand, bear the burden of proof that you are an employee of the company. So, in a lot of Supreme Court cases, the Supreme Court said, you initially bear the burden of proving the fact of hiring as well as the fact of firing. But everything in between is the burden of proof is placed upon me. Now, in those two instances, the fact of hiring, fact of firing, that is your responsibility. Burden of proof is upon you. Okay? Now, general number 4, substantial evidence shall be required. Okay, what kind? Substantial evidence, as we know, is in the lowest rung of the hierarchy of evidence. No? So, in administrative and quasi-judicial proceedings, the substantial evidence, as we have been asked to memorize, is such amount of relevant evidence which will lead the reasonable mind to accept as adequate to justify conclusion. Okay? Now, what is a good case of substantial evidence? Now, this has never been asked in the bar, but I have always been, I've always used this as an example in my classes. This is the case of Alilem Credit Cooperative. Bakit? Kasi yung facts nito napaka-peculiar, no? Now, what happened in that Alilem versus Bandiola, Alilem Credit Cooperative versus Bandiola case? It's a 2013 case. It's rather old, but then again, it's still good law because this exemplifies what is substantial evidence. Now, what happened in this case? So the question that was brought up to the Supreme Court was simply this. Are the sworn statements of the relative and common friends of an employee and his wife attesting to the existence of an extramarital affair, will that be considered as sufficient evidence as to justify the termination of that man for immorality? So in short, ano nangyari? No? So there was this man that was hired by this Alilem Credit Cooperative. His wife files a case against him with the HRD of that company. Okay? And that wife says, oh, I want you to terminate my husband because he is gallivanting with another person. This is an extramarital affair. I want him out. Sobrang galit siguro ng babae. Gusto niya matanggal yung husband niya sa trabaho. Now, the husband was given due process. He did not submit any explanation whatsoever. So the company was left with nothing, with no evidence except that which was provided by the wife. What did the wife provide? Yung written complaint niya, and then in-attach ng wife doon, the wife attached all of the affidavits of their family friends, their common friends, and relatives, mostly girls. Okay, saying, oh, totoo, meron nga na affair itong si lalaki. So, faced with that, the company decided to terminate and said, okay, there's already evidence of extramarital affair. This is immorality, therefore just cause for termination on account of serious misconduct. So the man now goes up to the Supreme Court. And he asks, ito bang ebidensya na to? Are these affidavits already considered as sufficient evidence or substantial evidence as to prove the alleged existence of an extramarital affair on my side, on my part? And the Supreme Court said, yes. Why? In this case kasi, the employer had no other evidence. And what did the employer have? As I said, it only had sworn statements of the relatives and the friends of the wife, whose name was Thelma. So, Supreme Court said, these sworn statements attest to the fact that they had direct personal knowledge of an illicit relationship between that guy, or they have knowledge of circumstances indicating the existence of such an illicit relationship. In which case, that is considered substantial evidence, therefore, he was validly terminated from work. Okay, yun ang sinasabing substantial evidence. Okay? Now, general rule number 4, no retroactive effect of labor. Exception, again, when the law explicitly provides for retroactive effect. Now, tingnan natin dito sa ECQ. Sinabi ngayon dito sa bayanihan law na whoever dies because of COVID, they will get 1 million pesos from the government. It is made effective today. Question, will a person that died from COVID 5 days ago, will they be entitled to the 1 million pesos? Okay. General rule says no when the law says, okay, because the laws are supposed to be prospective in nature. What is the exception? When the law itself provides for retroactivity, which is actually found in the Bayanihan law. The Bayanihan law says that anybody who dies from such and such a date, parang sinabi nila, from declaration of the enhanced community quarantine in February yata, something, then that will be considered as they will now be entitled to that 1 million, okay, from the government. Okay. Now, general rule number 5. In case of doubt or ambiguity, we interpret in favor of labor. Now, again, when there is only doubt. So let us try to, discuss 2 cases, no? And let me see if you can try to find to determine how the Supreme Court will rule in this case. Okay. So, ito isang kaso na lang para mas mabilis. Funeral and bereavement benefits. So, we're in this COVID school, right? And we have a collective bargaining agreement. In that collective bargaining agreement, which is now made part of the personal policies of the company, it says there, okay, may provision tayo. Kung mamatay ka in the line of duty, if you die in the line of duty, I will give you 50,000 pesos. You are entitled to 50,000 pesos. On the other hand, so paragraph A yon. Paragraph B, if you die but not in the line of duty and you are my employee, I give you 40,000 pesos. Okay? Now, paragraph C says, kung namatayan ka, if somebody in your family who is your legal dependent dies and you are my regular employee, then I will give you 15,000 pesos. Okay? So now what happened in this particular case? This guy, his parent was living with him because his parent was already retired. So he was practically taking care of his parent. His parent died unexpectedly and he incurred in a lot of hospital expenses. So he went to the HRD of this particular company and asked, "Ma'am, baka pwede ko nang kunin yung funeral benefit ko na 15,000 because my father died." So this HRD says, "Oy, condolence, ha? Okay, let me just check your record." And then she finds out, "Nako, iho, I'm so sorry. I can't give you the 15,000 pesos because your father is not your legal dependent. Eh. He is actually your legal dependent because you're married, is your wife and your minor children, your legitimate minor children." Okay? So yun ang sinabi ng HRD. Nagsumbong ngayon, this person, to the union. And the union said, "Wait, take a look at the CBA provision. It doesn't say anything. It just says death of a legal dependent. Okay? Death of a legal dependent, then you're entitled to 15,000 pesos. HRD naman on the other hand was saying, teka lang, but when we say legal dependent, we assume and we everybody knows that this is how the SSS defines a legal dependent. Should be if you're married, the legitimate spouse and or minor children. Okay? So, faced with that particular conflict, how do you think the Supreme Court decided in this case? Okay? Was the HRD correct in interpreting the word legal dependent in accordance with the SSS? Or was the employee in the union correct in saying that legal dependent could be anybody because it has not been properly defined in the rules and regulations of the company itself? So how do you suppose the Supreme Court decided this case? The Supreme Court here said the union and the employee is correct. The company cannot interpret it in the manner of the SSS because the rules do not do not refer to the SSS in the first place. So the Supreme Court said here, if the term or the condition, the CA provision is silent, Then the coverage of the term legal dependent that is found in the rule and regulation should be construed in such contemporaneous manner as social legislations have set. Meaning to say, kung paano naintindihan ng mga taong nagbabasa. Okay? So here, it did not say that legal dependent was going to be interpreted in the same definition as the SSS. So the Supreme Court said, let us define it in its most contemporaneous manner as legislation would have set it. So, ano yung isip ng mga tao? Sino independent? So any person who is dependent on another for daily sustenance and support is already a dependent. And so therefore, the Supreme Court said, bayaran mo na yan. Ibigay mo yung 15,000 pesos. Okay? Now, let's move forward. Now, let's go into employer-employee relationship. For the students, I want you to take a look at, employer-employee relationship. No, the terms employer and the employee is not defined in the first part of the labor code. No? Hindi mo yung makikita doon sa part book 1, book 2, book 3, book 4. Makikita mo yan sa book 5. No? Article 219, paragraphs E and paragraph. And the labor code says an employer is defined. So how do you define the employer? An employer is defined as any person acting directly or indirectly in the interest of an employer. No? The way by which they defined it is actually not nice, no? Because it defines the word by the very word itself. Parang sinabi mo, a rose is a rose is a rose, no? Now, mas maganda pa yung implementing rules. So I want you to take a look at the implementing rules. The implementing rules of the Labor Code, Book 5, Rule 1, Section 1, Paragraph S says, the employer is any person who hires or employs the services of others and who pays for the wages of people. Okay? Now, naman is an employee. So take a look also at Article 219, juxtaposed with your implementing rules. No? Sabing ganyan. And both would say, it is any person who is employed by an employer. So it is any person who is hired by an employer in exchange for remuneration. No? And it shall not be limited to the employees of a particular employer except when the code explicitly states so. Now, I want you to underline the third sentence. It says there, it includes one whose work has ceased in connection with any labor dispute or because of any unfair labor practice. Okay? But, even if he were dismissed, he questioned the legality of the dismissal in the NLRC. Okay? So, let us try to put it into this context. Now, because nag-ECQ tayo, okay, bumagsak tuloy yung revenues ng school. There are no tuition fees, and the school now, was not operational. In a sense, there's no school. What happened? No, wait lang. Ibahin natin, medyo mahihirapan tayo. Gawin na lang natin restaurant muna. Okay, let's call it COVID Cafe. Okay, so, let's assume there is no ECQ muna. So this guy was earning minimum wage and he needed more money. Jimmy, let's call him Jimmy. Jimmy was earning minimum wage and he needed more money because he had 10 kids. Okay? So he decided to moonlight after office hours with a competitor cafe. Okay? Let's call it, kung ito COVID Cafe, yung isa Ahini restaurant. Now, and yung general manager found out about this, and there is a particular provision in the employment contract, yung non-compete clause. So when the general manager found out about it, he investigated Jimmy, and after due process, caused his termination. So Jimmy now files a case in the the NLRC alleging illegal termination. Now, COVID Cafe, no, through the general manager, says in the NLRC, oh, hindi mo pwede. There could not be any labor case here because this guy, no, Jimmy, is no longer my employee. And therefore, NLRC no longer has jurisdiction. Question, is Jimmy still considered an employee for all intents and purposes under the labor code? Huh? The answer is yes. Because of that second sentence that I asked you to underline if you have your labor code with you, it explicitly states, no, that it will include any individual whose work has ceased as a result of a labor dispute. Okay? So it means therefore that if I terminate you, so as far as I'm concerned, you're no longer my employee. But if you file a case with the NLRC, the labor courts will consider you as an employee for all intents and purposes under the labor code. Which means therefore, okay, that is also the basis why you're entitled to full back wages if the courts find out that you had indeed been illegally terminated. Now, for the entirety of the time that the case is pending, since you are an employee, you're entitled to your back wages, and you're also entitled to vote. Okay, so by next week or on the second series, you will find out that you can also vote in the strike vote. You can also be included in the counting of the certification elections, etc., etc. Because for all intents and purposes, you are an employee of the company for as long as you filed the case. Okay? Now, why is it that you need to find out who are your employees? So kung ako, bakit kailangan malaman natin sino yung mga empleyado ko? Because I am obliged to follow and to comply with all the obligations under the labor code for those who I recognize as my employees. Now, we now juxtapose this with independent contracting, no? Why is it that there are instances where you find somebody working in this particular company, but they're actually not considered employees of this COVID cafe? Well, it is possible that these people who actually work in COVID cafe are not my employees, but are employees of a contractor. So now let's try to go into independent contracting versus labor-only contracting. Now, let me just give you an overview. Now, when we talk about independent contracting, and this is a term, no, which can be invariably interchanged with the word job contracting. So, independent contracting and valid job contracting, pareho lang yan. Now, remember there are two kinds of job contracting or independent contracting. One is what's called bilateral job contracting, where it's just you and me. Okay? So, example, ako yung COVID company, I hire a retainer accountant or auditor or a lawyer, no? That is a bilateral job contracting arrangement. Now, the other hand, meron tinatawag na trilateral job contracting where you have three parties involved. Now, the best example that I can think of is that you have COVID company and then you hire a manpower agency, which manpower agency now deploys janitors and messengers to COVID company or COVID cafe. Or another example would be, yung security guards. I will get a security agency. The security agency will hire security guards. The security guards will be deployed to me. Now, these people, the janitors, the security guards work within COVID cafe. Question, are they my employees? Then you have to determine now what are the ends of job contracting as against labor-only contracting. Now, overview first. Take note. In both arrangements, whether it is bilateral or trilateral, yung may agency, remember, COVID cafe must not have any control whatsoever over the manner and method by which the security agency, the manpower agency will do the job. Okay? So dapat walang control whatsoever. In short, results-oriented ako. I don't care how you do it, just do it. I don't care how you will secure the premises during this issue. Make sure that everything's safe. We will not have any nakawan. That's it. I don't dictate. I will not dictate to you how you will do your job. If that is the arrangement, then this is arguably a valid job contracting arrangement. Okay? Now, remember also, by way of an overview, you will hear, Department Order 18, 18A, and 174, which had been in the news prior to this ECQ. No? These are department orders issued by the Department of Labor to address the issues raised by the labor sector that management, a lot of companies have abused contracting arrangements. No? Now, please take note of this. Trilateral, this department orders 18, 18A, and now 174 is applicable only to trilateral arrangements where there is an agency, okay, and not to bilateral arrangements where we just talk, walang third party. Okay? So 174 only applies to trilateral working arrangements. So I think I forwarded to you yung slides where I had certain graphs, no? Now, remember, let us now go into job contracting first, or what is called independent contracting. Let's look at your slides. And says there, what are the basic premises in a valid job contracting or an independent contracting arrangement? So as I said, first premise, not everybody who works in COVID cafe are actually my employees. As I said, it could be that I had contracted out the job of security and the job of maintenance, cleanliness to third-party contractors. So, not all who work for me need to be my employees. Now, second premise, my right to contract out and the agency's right to accept that contract is a contractual relation born out of free will. So it's just a meeting of the minds. No? My management prerogative to contract out as against freedom to contract and earn a living on the part of the agency. Okay? Now, third premise. The third premise is that there must be a trilateral relationship. So you now see three things. You have COVID cafe, you have the independent contractor or the manpower agency or the security agency, and then you have the employees of the security agency, which are the security guards. So tatlo ngayon yung